So we have a subpoena for the Idaho 4 surviving roommate to testify on behalf of Brian Kohberger's defense. There's a motion to quash the subpoena. Let's get into some Idaho 4 updates. Hi, everyone. This is Empowering True Crime Alex, and my mission is to be a voice for the voiceless, to support victims, survivors of DV, SA, help find missing persons, those who can't speak on their own behalf. And I want to do it in an empowering and empathetic way. And if that's your style of true crime, you don't want the drama, make sure to subscribe to my channel. And of course, if you enjoy this, I'd appreciate if you like and share. All right, so let's get into it. BF was provided a subpoena to testify as a material witness on behalf of the defense. And I said I was going to do a deep dive in this. The thing is that it's been a long day and there were two attorneys who covered this. And I think they are exceptionally, and they actually have kind of opposing viewpoints. So if you want to deep dive into it, I am going to suggest two attorneys to watch. The first is the Tragos Law. Actually, let me first go ahead and I'm just going to go ahead and review what we're talking about from a newspaper, from a media source. So let me go ahead and do that. All right. So here's what's going on. Brian Kohberger's lawyers want to force victim's roommate to testify. This is an article from Newsweek. Lawyers for Brian Kohberger, the suspect in the Idaho murders case, have filed new documents seeking to have a roommate of the victim testify at his upcoming preliminary hearing. And of course, Brian Kohberger is the suspect who has been charged. He's been arrested for killing four University of Idaho students. That's Kaylee Gonzalez, Maddie Mogan, Ethan Chapin, and Xana Carnodo. Okay, so over the weekend, Kohberger's defense team filed a court document seeking to have BF, one of the roommates of the four murdered University of Idaho students, testify. F, along with DM, was one of the surviving roommates who found Kaylee, Madison, Ethan, and Xana fatally stabbed in the off-campus residence. The killings prompted a widespread investigation for a suspect. The New York Times obtained the court documents filed by Kohberger's legal team this weekend, which included a section from Richard Bethany, a criminal investigator hired by the defense. In the document, Bethany states that during the course of his investigation, he learned that BF has information related to the charges filed against Kohberger. Portions of information that BF has is exculpatory to the defendant, could show that he is not guilty, that he didn't do it. BF's information is unique to her experiences and cannot be provided by another witness. BF resides in the state of Nevada and is necessary to subpoena this witness because the witness's testimony is material and necessary to this case. All right. So in response, attorneys for BF filed a motion disputing many of the claims made by Kohberger's legal team, saying there's no authority for an Idaho criminal defendant to summon a Nevada witness to Idaho for a preliminary hearing. There is also no authority for an Idaho criminal defendant to summon a Nevada witness to an Idaho matter without a hearing. And there is no authority to summon a Nevada witness to an Idaho matter without a Nevada judge making a finding of materiality, necessity, and the lack of undue hardship, the document obtained by the New York Times added. In the probable cause affidavit for Kohberger's arrest, police included information following interviews with DM, who said she saw an unknown figure in the home on the night of the murders, which police matched to Kohberger's description. All right, so Jennifer Coffendorfer, I actually mentioned this, I think, yesterday in a short that I made. A former FBI agent told Newsweek on Monday that the court document filed by Kohberger's legal team may show that the criminal investigator they hired has uncovered something, interviewing lots of different witnesses that were in and around the house. Coffendorfer, who was not involved in the case, explained that during a preliminary hearing, the police officers who wrote the probable cause affidavit would normally testify instead of calling a witness to the stand. The officer would testify on everything that they were told by the witnesses. According to Coffendorfer, the defense team is likely going to be looking for BF's testimony to offset what was already revealed by DM, such as the sounds she heard on the night of the murders and the figure she saw walking through the home. Okay, so that appears to be the end of this. Okay, so the two bits of information then that I wanted to share. The first video was from Duty Ron. Duty Ron is a retired New York City, I believe it was a detective. He's a New York cop and retired. And he had attorney Melanie Little that was talking about the subpoena. And her side of it, I'm aligned with her side. She believes that whatever BH's witness statement, whatever she would testify in the preliminary hearing, even if she said that no, it wasn't him, no, it wasn't Kohberger, like whatever she could possibly say, it would probably still have to be reviewed by a jury, especially because there is evidence. I mean, we've already heard, we know that there is some type of DNA evidence. There is cell phone data. There is video, there's surveillance. So there is information that does place him there at the scene of the crime. And so can that really be offset? Oh, and of course, the other roommate's testimony, right? That she saw a figure that looked like him. So can whatever BF says really offset significantly so that he will be, so that the judge would rule that there isn't enough evidence to prove that he could have done it? I mean, really. So that was her reasoning. On top of that, the other thing that she mentioned is that, there could be a number of reasons why a witness wouldn't attend a preliminary hearing. Some people in the chat in Duty Ron's live actually said things like, there could be trauma, right? And so I feel like having a witness to testify on behalf of the defense, a suspect that killed her roommates, is just, can definitely be traumatizing. And for probably having PTSD, and scary, right? I mean, imagine being a witness in a murder trial, right? You have to put yourself in her shoes. And so I definitely empathize with her. And so that's my take. I feel like it is especially for the preliminary hearing. Of course, for the trial, absolutely. You would think that absolutely she would be there, right? Or that she would testify. So the second video I want to see, and I'll make sure to pin this in the description and in the comments, is Trago's Law. This is the lawyer you know. So he said, he actually, if you watch nothing else, I would watch his video. It was like less than an hour, maybe about 45 minutes. He actually reviews all of the documents. And this is what I was going to do, but I let you watch an attorney review the documents. He'll be much better able to review those documents than I will. So the side that he leans on is that he believes that it's good to have a material witness provide this information and testify if it could be exculpatory at the preliminary hearing. And his reasoning is that if there's something that could prove that that person is innocent, then you can let them out of prison now. You can avoid a lengthy stay in jail, dragging out a long trial, having this person in jail for potentially, I mean, he's already been in jail for four months or so, having the person in jail for a long time and having this trial drag out. What if they are innocent? If there is information that can be released now that they're innocent, then they can put, he didn't actually say this, but I'm going to say it on top of that, is that then they could put their resources toward finding the real suspect, right? We don't want to go through this entire 2-year process or whatever, however long it's going to be, a year or more process, to then have the person be not guilty and then have to start over who is the actual suspect. So that's his point. Again, I think he did a really great job of summarizing everything. So, okay, it's a 49 minutes. I'm going to go ahead and share this. There you go. He actually went right into Brian Enton's Twitter and used those documents that he found on Brian Enton's Twitter. So that is, and he's just kind of going through. He's gone through the subpoena. He's gone through, what was this document here? This was the certificate of Idaho judge to secure the attendance of an out-of-state witness. Okay, so You get the gist there. This is still some questions that I had, you see, because I didn't know that like that you could be subpoenaed to speak on behalf of the defense. I mean, I thought, of course, if the prosecution wants somebody to come, but imagine being called in for the defense, right? I feel like that's very scary, and this is also the reason why I do side with the other attorney on on just being conscious of that, really being empathetic, because I do feel like that could be really scary, especially if not at trial, right? So she's putting, she might feel like she's putting herself at risk by attending this preliminary hearing. All right, so this is what I wanted to go over because I did not know this. So, do witnesses have rights in a criminal case? A witness is a person who is authorized to testify during a trial. In a criminal prosecution, a witness's rights are protected. What is this? I don't want a lawyer. In a criminal prosecution, a witness's rights are protected under the Fifth Amendment. No one shall be compelled in any criminal case to be a witness against himself, according to the Fifth Amendment. Courts construe the rights of a witness in a criminal case to suggest that witnesses may decline to testify on the grounds that they could be involved in criminal activity. What are witnesses' rights in a criminal case? The right to avoid self-incrimination. So this is a practice known as pleading the fifth that basically indicates the witness is asserting their Fifth Amendment right to not testify against themselves. Once more, this right does not permit a witness to completely decline to give a statement. And the right not to be harassed. Although the Constitution does not explicitly grant this right, almost every evidence code contains some sort of prohibition on harassing a witness. This means that during a direct or cross-examination, a witness cannot be threatened, belittled, or subjected to the same question repeatedly. It is important to keep in mind, though, that if a witness starts to act hostile or uncooperative, a lawyer might be able to press the issue further. Okay. Okay, actually, I hadn't read this before, but this is really interesting. Are shield laws that prohibit lawyers from inquiring into sexual history with anyone other than the accused, number of sexual partners, and sexual inclinations, to use that to discredit, right? Because there is so much victim blaming and victim shaming in SA cases. So I thought that was really interesting. Okay, so a witness subpoena may be issued to anyone who could have information important to an ongoing criminal investigation. So if any of the following apply to you, a subpoena may be issued to you. Observed or heard about incidents linked to the case, have records or other proof relevant to the case, converse with those interested in the matter who are pertinent to it. Can a witness refuse to testify? No, a witness does not have the same right to avoid testifying as a defendant has. Accordingly, a witness may be forced to testify. The witness may be held in contempt of court if they refuse to testify after being ordered to do so. While a witness cannot decline to testify, this does not obligate them to provide any requested information. Generally speaking, a court can compel you to testify after issuing a subpoena outlining the specific testimony they require. Only a few grounds exist for excusing someone from testifying. 1, the testimony contains evidence that implicates the witness. The Fifth Amendment of the Constitution guarantees you the freedom to refrain from offering self-incriminating testimony. A witness has a right to invoke the Fifth Amendment's protections at any time in order to decline to provide an answer. In a criminal case, the witness is a defendant. The Fifth Amendment's protection has been expanded by this. Never can a criminal defendant be compelled to testify. A witness is wed to a party in the dispute. Courts view communication between spouses as privileged. This indicates that you generally cannot be made to testify in court against your spouse. One party's lawyer, therapist, or priest is a witness. Individuals in these occupations are expected to open up to them without concern for the repercussions. Therefore, the court accords these partnerships with exceptional protection, and communication between the two is typically confidential. The witness is incompetent to testify. Some witnesses are unable to testify because of conditions that make it difficult for them to recollect events and describe them to a jury accurately. However, crossing this threshold is quite challenging. For instance, even though small children may not be the most trustworthy witnesses, many courts may allow them to testify. The jury is then free to decide whether or not to believe the witness' testimony based on their age. It's possible that you must testify if you don't fit into any of these categories. What happens if a witness refuses to testify? You must follow the order's instructions if you are served with a subpoena to testify in court. This indicates that you must show up at the designated spot and the precise time and date mentioned in the subpoena. You must abide by these requirements as well if your subpoena also instructs you to carry specific types of evidence at the location where you're expected to give testimony. Once more, anyone who refuses to appear in court as ordered will be found in contempt of court and given a jail sentence. So there hasn't been a hearing set on whether or not BF is going to actually testify on behalf of the defense. So that hasn't been scheduled yet. The Trigos Law guy thought that there probably would be a hearing for that, but as of right now, as of this moment, at the time that this is filmed, recorded, there has not been a hearing set to determine whether BF is going to testify. So let's see, it's in June 28th, I believe, was a date that she was set. So that's weeks away, 2 months away, April, June. It's 2 months away. So there's plenty of time to have a hearing to decide whether or not, but the defense gave her plenty of notice to testify at the preliminary hearing. Make sure to watch those 2 videos if you want more in-depth information on this case from 2 attorneys. All right, so what do you think? I'd love to hear your thoughts in the comments. If you enjoyed this video, if you learned something, make sure to hit the thumbs up. Help me out as I grow my channel. And of course, subscribe if you want to get more updates on the Idaho 4 case and other empowering true crime news. All right, everyone, stay safe, stay thriving, and have an empowering week. Bye for now. Don't forget to like, subscribe, and hit the bell button for notifications. Thank you.